can start by taking roll. Hartston,
Here.
Kirkmeyer,
Here.
Sarouche.
Here.
Okay, we have our full working group. And I can look to see if there are members of the public. We have a few members of the public. If anyone wants to make a comment, please raise your hand using the Zoom function. I don't see any raised hands. So
Okay.
I'll pass this on to you.
So how would we like to proceed today? Andrew put together, I think, a list of the last time we talked, we began discussing how to present the rules to the full working group at the next meeting. And Andrew was kind enough to put together a groupings of the rules. Those that we will place on a consent agenda vote and by chapter, I think following Amos's suggestion that we take each chapter and try to group the rules that really just restate the disciplinary standards that apply to lawyers and have them apply to paraprofessionals. And then also have separate votes on particular rules where we're either imposing a higher standard or making some substantive change, or we know that there's some controversial issue or issues underlying the rule. And so I don't know if the subcommittee has had a chance to go through what Andrew has done. Has everyone had a chance to review his work?
I did so briefly, and it looks good to me. I'm interested, Andrew, to hear from you how it feels this way to you, or if you have recommendations by taking a close look of suggestions for either changing this or not, because it looks good to me.
Yeah. Oh, sorry. Go ahead.
I was just going to say I agree. It seems to me like things like if they're not the same because provisions regarding criminal law have been removed or class action or things like that, I think it's a slam dunk for a consent vote, like in the consent category. And then we may have to kind of look at the others that are different, not the same, more restrictive, for different reasons that may generate controversy. I've also just kind of scanned it, but thank you so much for this work. It's really great.
No problem. Yeah, I would just recommend first looking at the table and just saying, this was just my recollection. It's your call, just based on the conversations and discussions thus far as to the rules that might, quote unquote, qualify for an individual vote. So that was my first cut. If you think something designated for individual vote could be moved to group, or something that's in the group could be moved to individual, please let staff know and we can make an adjustment. So I think that would be the first thing for the group to determine. And then second, this might be, I might be walking through a wider door than you opened for me, Amos. But one thing is, in terms of the groupings, I know you asked it to be grouped by chapter, and that's fine. I mean, we could certainly do that. It's just when I send when you send the email, and there are all these attachments, I wonder if the group just might want to consider once more as to whether or not the quote unquote group vote could be taken once. And again, allowing all the working group members to have a pass in advance of the meeting to look at the list of rules and ask to pull anyone out. That just might save time. That's the only thing that came to my mind when looking at this. But other than that, it's up to you guys how to proceed.
I will just say, oh, go ahead.
Just really quick, one thing that we didn't put into the table that was used by the Rules Revision Commission in presenting to the board and is really a next step after you've had a chance to look at it, is actually picking the representatives from the subcommittee who would make the presentation. And you have some options there. You could do it by chapter, or what we did with the Rules Revision Commission is we had whoever was really the point person on a rule that might be up for an individual vote, they sort of naturally appeared to be the person to present it to the full group. And so if when you go through this, you see that there are individual votes and you agree that that's the approach to be taken, you might want to pause to say who would volunteer to make the presentation.
Yeah, good point as well. I'll say for Andrew's point, I did have the initial reaction that you might suspect to your email, which is that's a lot of attachments. Maybe dividing it up in that many segments might not be the most efficient. Logically, it makes sense to me, and I feel like we, probably better to go in somewhat bite sizes through this so everyone can review it and pay attention. But I do think it's a lot of attachments and it might be divided up a bit too much.
Yeah, I agree. I think we should consolidate it some more or do a one like Andrew's saying. Yeah.
I'll also say the chart is very helpful. I would like to suggest edits. Again, I guess it depends on who's making the presentation. Particularly the middle column on the chart about the same or not the same and some sort of description. I think, especially for the ones that are individual votes, I feel like we could use that space a little bit more to sort of justify the diversion or what we were thinking. Just because I think it's some people might focus just on the chart or it's a starting place. So I think that it's a very useful tool, and I think we might want to take a look at that middle column, how we might want to adjust it. At least for me, as we've discussed before, I don't start necessarily with the attorney rules, and so the key difference for me isn't same or more restrictive. It's more of a there might be some justification for what we're doing, particularly in the individual vote rules.
On Andrew's first question, is it premature for any of you to say that you have rules that you would take out of the chart or put into the chart? When I say the chart, I mean the items that are going to get an individual vote. Because I'm just thinking about finalizing this document, giving the working group ample time to review it. We would want to do it sooner rather than later.
I guess one question I have, because it seemed like there were a lot that were individual votes that I'm surprised that we would have as individual vote. But I wasn't on the original, so I guess I would have to look to Amos and Fariba to say like, oh, these were things that had previously had more discussion around them. Because I thought there were a lot of them that seemed, not a lot, but some of them that just seemed like more that they could be on consent and let people pull them off if they actually had an issue with them. So Andrew, just wondering if I could get your thought process on maybe why, it seems to be a little bit higher than the ones we were talking about under consent.
Yeah, again, this is just my sense of things. So a good example of that for me is Rule 1.8.1. I personally feel that it's justified to retain and would be suitable for a group vote if I was the commissioner and of the league and able to make all the rules. Sorry, the All-Star game is still on my mind. But I realize, I believe at prior full working group meeting, I think some members of the working group had some concerns around Rule 1.8.1. So for me, trying to be conservative and cautious, I mark that as individual. And there are other rules like that. I believe organization as a client, I think amongst this group, my sense was there was no disagreement that shouldn't be recommended as removing the rule. But again, just in this bit, my recollection might be vague. I just had a sense from the full working group that there was extended conversation about that. And so I just marked it as an individual vote. And same with sale of a law practice, should paraprofessionals even be owning a law practice? And that brings it into a broader discussion. And thus I marked it as individual. But I take your point, Kim, and we can certainly go through the list. And we could, if you have a different view, we can reorient this.
I'll just add a few comments on those particularly those two rules, because I think the reason you may have highlighted them, the reason we had a lot of discussion around them is really had less to do with the rule itself rather than the concept that it implies, right? So and so organization as a client, we're essentially removing that rule, which is a rule that just reminds lawyers that when you're representing an organization, the organization is your client, and it provides a mechanism to guide lawyers when they believe that there's some constituents of the organization that are engaging in harmful conduct and what they need to do and what they can't do. And so really the reason to highlight it is because the recommendation, I think, from this group is that paraprofessionals should not be permitted to represent organizations, which is not the purpose of the rule. The rule assumes that organizations would be clients for paraprofessionals if it would be adopted, but we're taking it out. So I'm wondering if for that big windup, whether or not it should go into a group vote, because if we really want to talk about the underlying issue, we should probably talk about it separately in some way, rather than using this as the vehicle for discussing that particular issue. Similarly, with the sale of a law firm, I think there's consensus within the working group as a whole that paraprofessionals should be permitted to own firms, at least among themselves. There's more controversy around sharing the ownership with a lawyer, and that's really squarely dealt with under 5.4, which we have designated for an individual vote. So I'm not sure sale of a law firm probably needs an individual vote on second thought. So, but that's just my feedback. Would it be helpful to just go through to pull up the list for everyone to see, and we could just go through and decide if there's consensus among the subcommittee members about what we should have designated as individual votes?
I think so, because there's several that I think should also go to group vote.
Okay.
Are you going to pull that up, Greg?
Yeah, I'll try to share my screen.
Okay.
Since I'm so good at it now. Let me bump it up for you. And we'll go to the beginning. All right. So I think the first three that we have designated 1.4.2 and 1.4.3, first four, 1.5 and 1.5.1, actually 5 and 1.5.2. Is there, of these 5, does anyone think that we should designate any of these rules for group vote? Because I think it's pretty clear that we probably want individual votes on each of these.
Agreed.
Agreed.
Okay. I mean, the only wobbler I would see among this group would maybe be 1.5, because we're essentially adopting the unconscionability standard that applies to lawyers. We are adding one new factor though, so that may be a reason to.
Well, and it was the limit on contingency fees.
Oh, right. Yes, in the contingency.
That's why
Okay.
I marked it. Otherwise, I agreed with you. I would agree with you.
Okay. And then we were just talking about 1.8.1. Andrew was mentioning if he had his druthers, it would probably be a group vote, but there was a lot of discussion around this rule within the subcommittee.
Yeah, so this one is tricky because since we're following the attorney rule, I tend to think it could be a group vote, but I think we did originally seriously consider prohibiting business transactions, and that might be something that the full group wants to consider.
Fariba and Kim, do you agree?
I don't recall that there was a controversy on this one, that we all agreed.
Well, I think Amos is correct that he originally, and I think it may have been before Kim, you joined the group, but originally I had highlighted this as being a policy issue that the subcommittee should think about. And it's, essentially, again, it's an ethical rule that requires a paraprofessional or lawyer to obtain consent. It provides guidelines for a paraprofessional lawyer whenever they're entering into any kind of business transaction with a client or obtaining a pecuniary interest. And I think the group originally thought, well, we shouldn't allow paraprofessionals to even engage in that kind of business transaction with a client. And instead, this should be a straight prohibition. But then there was some discussion around the ability to place liens for fees, and that may be a useful thing for paraprofessionals to have. the ability to do. And so I think, went back and just to give a recap for Kim, we went back and decided to adopt the lawyer rule.
Mhm.
Right.
Right.
But there's a policy decision that underlying that may be worth keeping separate or highlighting for the group, I think.
Okay.
We're highlighting as an individual vote for the group because
Because the majority of the working group might feel like we should prohibit business transactions with clients other than legal services that are being performed.
Was there a discussion on that? What gives you that idea? Because I don't recall. That could be just me. Sorry.
No, that's what we originally thought. That's what.
Right, but we
that's the
don't
ball.
think that anymore, right? So I'm just thinking, why can't we just move this to a group vote?
And anybody will be able to pull these off at any time too, right? Kind of like a consent calendar, and then people can pull them off and say, you know, I want to discuss this one. And if we send it out early enough, which I think we're pretty much ready to do, right?
Mm-hmm.
For it, then we can say, if you want to pull any of these that are on group vote, you could pull them off, and then we can just be prepared for it. Obviously, we might be on the spot for some of them, because they'll be like, oh, right now I want to pull it off. They don't get to us ahead of time. That would be the only problem we'd run into, but probably there's enough individuals to be able to do that on the spot.
Yeah,
I'm okay with that.
but I want to make sure that it's not one of us that pulls it off. The consent.
Yeah, right, Rita.
Now that's the
I
purpose of
agree.
this discussion.
Right.
Maybe we
Yes,
should-
we could do that. And I think one of the other things we can do when we share this with the full working group is make it clear that if they have any questions about what the rule means and how it operates, that doesn't mean they need to pull it off the consent agenda to have that discussion with the working group or with the subcommittee members. And certainly they can pose any questions that they have to staff, and we can provide some additional information on any particular rule that's on the up for group vote, without having to go through the additional step to pulling it off and making sure that we have an individual vote on it. That may, I mean, after they get the additional information, that may lead to that request, but we certainly can engage in conversation with them about any of the rules.
Mhm.
Okay, well,
Just a point of clarification on this one. If somebody wants to pull it off the consent calendar because their position is that this should be banned altogether, right? So you were so this would not allow, for example, we have the statute allowing family law attorneys to file a lien, family law, real property lien. So if there's a ban, paraprofessionals who practice family law would not be able to do that. Is that what you said?
well, if we had a ban on them entering into business transactions with a client, then it essentially would operate that way, because they would otherwise face discipline if they.
Okay, so
That would be actually acquiring a pecuniary interest adversely.
adverse, right?
Yeah.
Could I
So
jump
if-
in really quick, Reba? Just
sorry,
to
go
help.
ahead.
Just to help. I hope this helps clarify. Right now, there is a ban to enter into a business transaction or obtain an adverse pecuniary interest against the client, unless you comply with the steps of 1.8.1. If you removed the rule, it's my view, I don't think you would have a quote unquote ban. You would have to write a new rule that says, under no circumstances, you know, if that was the result that the working group wanted to achieve, a quote unquote ban. If there was no rule, then I think they could try to assert liens, and it might harm the client because they wouldn't have these protective elements that are in the rule, which are intended to protect the client. I hope that helps
I'm just pulling up the rule just so you can see.
with
it.
your question about whether there'd be a ban or not a ban.
Right, and the reason I bring that up is because I think we need to, at least I want to be clear on, if somebody wants to pull something off the consent calendar at the day of the meeting, I want to be educated enough to, and informed enough to be able to say what the repercussions are. So for example, here, as you just said, Andrew, if somebody wants to pull it off and propose a complete ban, we need to come up with a new rule. We couldn't, right? To address these situations.
That would be my view. If that was the result, but I think, and again, I apologize if I'm misunderstanding. If someone simply says, I want to pull it off the consent calendar, that means they just want an individual presentation and or discussion. I don't think that they can stop a vote. So the full working group would still be able to vote, and the majority of ayes would carry the day. It might be a close vote, but as long as the majority of the working group voted yes, the rule would still pass. If it was voted down, now getting to your question, and the will of the majority was, we wish to ban this in all circumstances, then I think it would come back to the regulation subcommittee to write a rule that could effectuate that.
Thank you.
I don't know if Greg or Randy disagree. That's my sense.
No, that's my understanding too.
So
Okay, so where do we stand on this? This is the rule, just if it's helpful to see it again. And this is what Andrew was referring to. The way, and this is the style that we use in a lot of different rules, is which is they shall not enter into a business transaction or knowingly acquire a pecuniary interest adverse to a client unless they satisfy these requirements.
I kind of think if one of the subcommittee members wants to leave it on the vote list, we should just leave it on the vote list.
No,
Yeah.
but for this one, I'm fine. This one, I'm fine. You know,
Okay.
again, I might suggest that on the table that we put a little bit more information in the middle column instead of just saying same, just so we could highlight maybe some of these issues. But I'm fine taking 1.8.1 and putting it to the group vote.
I would agree with that.
Okay.
Me too.
Thank you.
Can I ask a quick procedural question? Because I'm looking at the one you just brought up, Greg, and I'm looking at my list that I've had. I'm kind of keeping a running total of what we're doing, but on it, it has like the lawyer, you know, the attorney law, and then you've crossed, or the regulation, and then you've crossed it off and showed it for the paraprofessional. And the one you just had was a clean one. Are we we're gonna show them the attorney one that's crossed out? Because I do think that sometimes is really helpful. I mean, maybe we do both, like a clean version with whatever, but on the one that we were just looking at, I mean, this is the one where you're making those changes. I just want to make sure we're doing that.
So I could jump on that. I took a little liberty. At some point, these rules are going to have to come. We've been working in Redline, and Greg had a very helpful draft, and I just wanted to try to take initial stab, and I refer to it just as illustration purposes. How would it look clean? And so, you know, I didn't mean to make I don't think a determination has been made as to how to present. Maybe that's worth a conversation if you want the clean and the red line, or just one or the other. This was really just for you guys and for this meeting. Look at all the work you've done, and this is how the clean version of the rule is going to look. Should it, you know, make it all the way through? And here's how it looks as compared to the lawyer rule from where we started.
Okay, that's helpful, Andrea. I just think it's helpful for individuals to know we're not straying too much from what attorneys have sometimes on certain ones. Okay,
Absolutely.
I'm good.
Yeah.
Okay. All right. Andrew, are you keeping score of what we're doing here? So
Yep. Right now I got 1.8.1 group vote. That's the only change I've got so far.
Yeah, and Amos also requested some more information about this particular rule, since it did warrant so much discussion in our group, even though it's the same. Make perhaps a brief description of what this rule does.
That's totally fine. Any of the, you know, this was just staff's cut at just trying to describe what the changes were. So Amos, do you want to, is there language you have in mind that you want to offer, or I mean, how do we want to go about changing the language? It's in a Word document. If anyone wants to make red line changes, or however you guys want to go about it. My hesitation is trying to come up with language that's not achieving, you know, what you're desiring.
Yeah, so I'm happy to work on that with whoever wants to work on that with me. I'm particularly interested in doing that for the individual vote rules, because I think that's where I think we want to give a little bit more information. We might give it orally, but I think right on this chart is a good start. And this one is going to be a group vote, but I still think it probably warrants a little bit of explanation. So I'm happy to put a draft of that together and circulate it.
Okay.
I can work with you. Happy to help out. Maybe
Great.
is it possible for us to meet?
That's a good
to go over
question.
this? We've done that before, but I just want to make sure we're following, we're
We can
compliant,
talk, we can talk
Why
about
don't-
that separately, but I think we'll have to be careful.
right?
Well, let's go through it because I think once we decide on which ones have individual votes, I think we should go through again and, as Randy suggested, maybe assign one subcommittee member who will take the lead on that particular individual vote. That makes sense.
Great.
Okay, so the next one was organization as client. And I don't know if the group wants to put this on the group vote slate or not.
I think this should be a group vote.
Okay.
Agree.
Okay, so that will be a group vote as well. 116, declining or terminating representation. We added A5, which really deals with the fact that we're dealing with, we have a professional who has a limited license to provide legal services, and what their obligations are when it becomes clear that their client is in need of or requesting services that go beyond the scope of their licensure. And so that is different. And it's a different requirement than what is imposed upon attorneys. So is everyone in agreement that should be an individual vote?
Well, do you think it's controversial? I wonder if it should be a group vote with the more fleshed out explanation. With the explanation of what it is, but I don't know that anybody's going to disagree with it or I don't know.
Yeah, I think that's a good point, Leah. I think this is one of those areas where the subcommittee may want to underscore the fact that we are adding this restriction in, because I think it's important to note it as an important public protection measure that the group has adopted. But I don't think it's necessarily going to be that controversial. I think there probably is going to be broad support for this.
And I agree because it's necessary because the nature of the license is limited. So this is
Right.
So I would vote to move it to group vote.
Maybe it's a group, but it's a highlight in
Right.
whoever's going to talk about this section, say we added this in for consumer protection.
And I think perhaps in whatever memo accompanies this or something, there can be, especially for all the rules are in the group vote bucket, there's several where it says not the same, and looking at that and trying to decide what areas do we want to highlight that's where we're imposing a different obligation upon paraprofessionals and attorneys, just so people are aware of it, because people are going to gloss over after a while looking at 71 rules in red line. So it might be helpful to have those things called out. All right, so that sounds like you're in agreement that should go in a group vote, but just be highlighted in some way that we are imposing this restriction. 117, again, I'm not sure this is a very controversial rule. It just tangentially relates to a controversial issue, which is more squarely dealt with under 5.4. Is everyone in agreement to move that to a group vote?
Yes.
Okay. Trial publicity, I think we designate this as an individual vote because it was added late based on a comment from Steve Fleischman. But again, I'm not sure we would need to have a individual vote on this. And Steve, if Steve wants one, he can certainly request one, but I don't think it's necessarily going to be a controversial issue.
I agree because paraprofessionals will not be practicing criminal law. So this is a slam dunk for me in terms of moving into group vote.
I agree as well. And again, for the other reason, which is I think originally we weren't going to include this rule at all. And I think we decided to go ahead and include it because paraprofessionals will be practicing at trials. So I'm fine with group.
Okay. Okay, 5.3.1, which is this is the rule where if a paraprofessional or paraprofessional's firm wishes to employ a disbarred, suspended, resigned, or involuntarily inactive lawyer, they need to comply with the registration requirements and supervisory requirements under that particular rule. This is probably going to be controversial, and I would imagine needs to stay an individual vote.
So, and this raises another aspect. Does this rule apply to ineligible paraprofessionals, ineligible lawyers, or both? Has the group discussed that?
Good point. I thought let's see.
I think we did.
So the title says lawyers or licensed paraprofessionals. So I would think it would apply to both.
Yeah, I think we did discuss that. Now,
Okay.
So do you think this is because we're leaving the rule the same as the attorney rule? Do you think it's going to be controversial because the group may or somebody may want to have a complete ban?
Yeah, I think we heard that, in fact, at the last meeting.
Yeah, I think this will be controversial because essentially it creates the possibility that a wholly owned paraprofessional law firm could be employing disbarred attorneys.
Oh, that sounds terrible.
Well, we have this rule in place right now to allow law firms to employ disbarred attorneys, but the purpose of the rule, because they're disbarred, they're no longer licensees of the state bar, so we have limited ability to regulate them, but we can regulate the people that employ them at the law firm. And so the purpose of the rule is really, one, not to foreclose the possibility that they can employ a disbarred attorney, because some disbarred attorneys are endeavoring to rehabilitate themselves and bring themselves back into the fold. And I think we should probably provide them the opportunity to do that. And one way they do that is by working as a clerk or working within a law firm. But the purpose of the rule is to limit the things that they can and cannot do, and to make the lawyer who's employing them in a law firm make the state bar aware that they're employing them, and also make certain disclosures to clients, so clients are fully aware that they are employing this person, and then they may work on their matter, and then also informing the state bar when they're no longer employed.
Mm-hmm.
So these are consumer protection safeguards that we have within the rule. So the question is, I mean, I think we talked about this last time, but the group had decided that we would allow paraprofessional law firms to do this.
So
it may be controversial. I'm sure it will be, actually.
Well, here's the way I look at it, and I may be quite wrong, but I'm thinking if between the three of us, we agree that something should be grouped because we agree with what we've done here, what we're recommending here, then I think it should be put on group vote, and we can let, in the group meeting, somebody can pull it off and we just be ready to have a discussion. So for example, right now, I'm wondering, Kimberly and Amos, how do you feel about this particular provision? Do you think it should be left up to individual vote, or do you believe that it should be group vote?
So I'm coming from the perspective that the group vote is for where we think things are controversial, and we want to highlight that and make sure it gets a specific vote. And I do think this is one of those. The three of us have agreed, I think, on pretty much everything. So if we decided to put the stuff that we agreed on, I think everything should be a group vote. I think there's very little disagreement or space between the three of us, but I think there are some clear rules that are very controversial that, warrant individual vote.
Sure. So for example, 1.16, we decided to move it into group but highlight some important information to have some explanation. So I'm just wondering, why can't we do that for this? I'm sorry, Kimberly, I interrupted you.
Oh, no, not at all. I was just saying, if we think anything's gonna be a split vote, like, it's not gonna be kind of a consent, which it's probably, none of them will be 100%, consent. But I think we need to take it off ahead of time rather than having it done there. And this one, I don't think that you're gonna get individuals that are gonna agree on this. So I think you should just take it off ahead of time, and that kind of saves you. It'll make sure that you're ready to vote on it and everything individually. That's kind of where I'm coming from, trying to use this more as a consent calendar.
Yeah, maybe a good way of thinking about it is if you anticipate that there are going to be any working group members that are going to vote no on the group vote based on their opposition to a single rule, then that single rule needs an individual vote. Because we don't want them voting no against 50 some odd rules simply because they have an unresolved issue with one or two particular rules that we have included in the group vote.
But isn't that why we, if I'm remembering my Robert's Rule of Order correctly, that we, before taking a vote on the group, the list of provisions on the group vote, we ask if anyone wants to pull anything off, right?
Right.
So that way, that one person you're talking about would say, hey, I want to pull this off, or this and this and this off, and I'm okay with anything else. I don't want to take our time here. I just don't want to, waste all the discussions we've had, and we have consensus on most of these. And I just don't want to create a long list of individual votes when the three of us agree that it should be group vote, and we'll just let people pull it off the consent calendar and just make it really clear. If you disagree with any of these, if any of these are controversial for you, this is the time to pull it off. Just putting it out there. I don't want to take more time.
Okay. So let's move on. I think the next one was 5.4. I don't think there's everyone agrees that that's probably an individual vote. Probably the most important individual vote. 5.5 is designated for individual vote because it is, it's more restrictive, much more restrictive than the lawyer version of the rule. It really gets to the heart of some of the issues that people have raised around approval of this limited license and how exactly we're going to police it. So I think that's why it's designated for individual vote. Does anyone have any question about that or want to put it instead in the group vote category?
So this is one I don't think will be controversial, right?
Right.
I probably not. We haven't heard anyone complain about this particular rule. Let's quickly just pull it up. But I'm not sure how many people have actually looked in detail at all the rules. This is the big difference. But I'm not sure. You're right. I think it could easily be designated for group vote. And this is a good example that you're speaking to, Fariba. This is a good example of if somebody really has an issue with the way this is drafted, we can pull it out. But I haven't heard any opposition to the way we've drafted 5.5.
Yeah, so I'd be fine putting this one on group.
Okay.
Yeah, I agree.
Okay.
Sorry to circle back. What was the final resolution on 5.3.1?
I think it's still individual.
Got it. Okay,
Yeah.
thanks.
So these two are individual, but 5.5 is going to be a group.
Got it.
Okay, 7.2, the advertising rule. I don't know how controversial it's going to be, but there has been a lot of discussion about this particular rule, and there are significant changes that we've made as compared to the lawyer rule.
I agree with this being individual.
Okay.
7.2 and 7.3.
Yeah, 7.3, we're incorporating the running and capping issue as well, which has been the subject of a lot of discussion. So, okay, so misconduct is here because this is we're adding right now some, well, I guess they're bracketed changes right now, right, Andrew and Randy? Adding in the provisions from 6068 that are not covered under the rules of professional conduct. At least two of the duties that are set forth in the statute.
I think, won't individuals agree with this one though?
I would imagine, but we haven't really talked about that. And partly because I think the group is, we're still, this is something that Brady was going to cover in terms of statutory changes as well.
Yeah.
So I'm not sure whether this really warrants an individual vote at this point.
So just to clarify, last meeting, staff offered for illustrative purposes how the rule might look if we added 2 statutory provisions. In this latest draft, I took those out. I'm not sure that for 2 reasons. I'm not sure that the 2 were agreed to by the regulation subcommittee, and I'm not sure we've had a fulsome discussion as to what to put in addition to that rule. So
yeah.
So as of right now, it looks like the lawyer rule, and I would agree, it's non-controversial. The open question is, what do we want to do about statutory provisions?
So my suggestion is that we put this to group and that we have the placeholder, and this might depend more, Brady, on your schedule of when we're going to go through the statutory provisions and propose to add some of them. But since right now they're not added, I don't know that there's anything for us to take an individual vote on.
Well, and I think that there were, of the statutory provisions, 3 of them were about more programmatic, about the duty to cooperate in disciplinary proceedings, the duty to self-report things like lawsuits and felony convictions, and the duty to keep your licensee records up to date. And I think the thought on those was just to recommend to the legislature that they be also made statute for paraprofessionals, and then if not, to put them in the state bar rules, because they sort of more go with that than with this sort of these rules, which are about sort of your conduct out in the real world. The 2 that at least as staff we had discussed including here were the provisions on reporting, and I have notes I was going to present on this if we had time today, immigration status, and advocating overthrow of the government. So I think those are the 2 that Andrew previously had placeholders on. And our recommendation was because similar to the statutory provision on sexual relations with clients, which we imported here, they sort of fit here. And I don't know, we
Go ahead, Brady, sorry.
We added the sexual, we added the additional sexual relations prohibitions, but we didn't add the immigration reporting and advocacy of overthrow of government. But I think those are the placeholders that Andrew had. And when we discussed them at the last working group meeting, when we previewed this, it didn't seem controversial.
I think at the very last meeting, or just not last week, but the week before, I think we did add them in when we were going through those sections, didn't we?
I think I don't know if we officially did, but I think it was not controversial. I think all 3 of us agreed those 2 look good. I think the placeholder part was that there might be more coming out of because we hadn't yet gone through Brady's memo and the different statutes. So at least my feeling was there are placeholders because there may be additions that we haven't yet covered. Brady, are you saying that you don't think there will be? You think those are going to be the only 2?
I mean, unless you wanted to also make a rule about in these rules about self-reporting, licensee records, and the duty to cooperate in disciplinary proceedings, all 3 of which are necessary. And we thought it made sense to go through statute or the state bar rules. But if you disagree, if you think they fit here, they could go here also.
So my suggestion revised is to put back in the 2 placeholders, which I think we were comfortable with. I don't know if that means we take it off of group or if they're individual or not, but I think I think we're comfortable, and at least for me, I think I'm comfortable with those two additions.
And me too. I'm for some reason I thought we did that last week or 2 weeks ago.
I think it was in my final version as well.
Yeah. And I even think I'm not sure about the records. I'm getting confused with when I read Brady's memo for the other meeting. So, but I know that the overthrow government, I'm pretty sure we added that last time.
I think I raised last time the question of, are there any rules about retention
More.
of documents and how long? Because I do think that might be an important addition, but I don't think we have language on that.
Although, so this statute provision is just about, you need to keep your address, phone, all that sort of stuff up to date with the state bar.
Yeah.
Right, but I think at the last meeting, I think it was the last one where we talked about additional provisions. At least I had the question of whether there is any rule or statute that requires the retention of certain documents for a certain number of years. And if not, if that was something we needed. So I don't know where that stands.
For lawyers, the only one I'm aware of for lawyers are in the criminal defense context, that there's a new penal code provision requiring retention of client files for the period of incarceration.
Yeah, that's relatively new, like you said.
Yeah. But other than that, I don't think there's anything in statute requiring an attorney to maintain the file for any period of time. I mean, you're required to turn over the client file at the conclusion of representation, but not to retain a copy of it. So that would be, I mean, that would be something different. That would be something an additional standard that would apply to paraprofessionals that wouldn't apply to lawyers. Well, so from my count, we have 9 rules now designated. If we deciding that 8.4 goes in group vote, which it sounded like there was consensus around that. 9 individual votes now designated as opposed to 16. So that's better. Why don't would it be helpful to just try to assign each subcommittee member 1 or 2? It may make sense to group some of these together as well, because especially these first 3 kind of work together, the notice to consumer and informed consent and written agreement. But that's also a lot to bite off.
I think Greg, I think we're all hoping you're gonna do some of the heavy lifting, but I'm happy to do these. I pushed kind of hard on these, so I'm happy to do it unless anyone else wants to.
I think Fariba and I were hoping you'd say that, Amos.
I'm still hoping Greg will have a change of heart.
I'm happy to pipe up certainly, and also provide context around any of these rules as well, so that people understand exactly what is being done. But I want to make sure I leave the policy arguments to everyone on the subcommittee, because I do not want to be in a position to advocate for any particular position. So I would group then 1.4.2, 1.4.3, and 1.5.2 together for Amos as the lead. And then we would have to designate somebody to talk about fees for legal services. Probably the fees for legal services and fee divisions can probably be coupled together. Kim or Fariba, would you be interested in taking on either or both of these roles?
I am oh, go ahead, Fariba.
I was just asking for fees for legal services.
Just the contingency.
Yes, right? It's just the contingency fee.
Yeah.
Yeah, and a new factor under 14, which is a factor that we added, a factor for considering the unconscionability of the fee, which does not apply to lawyers.
Yeah.
Which is something that we adopted from the ABA model rule.
But then 1.54.1, which I just thought I heard you say you want to group the 2 together. That's like that was really controversial.
Yeah.
I don't know if we want to Well, we could group it together because
No, I'm not saying group it together. I'm just saying in terms of assignments to the subcommittee members for handling
okay.
discussion, for leading the discussion on those, not grouping them together in a vote. So there's still going to be, so for instance, Amos is still going to, Amos is going to talk about 1.4.2, 1.4.3, lead that discussion essentially, and 1.5.2, but we're going to take 3 separate votes on each of those rules still.
Yes, I got that. Thank you.
Yeah, but it made sense to kind of group those together for Amos because those rules kind of interlock with one another and operate together in some ways.
Mhm.
So 1.5 and 1.5.1 probably less so in terms of an interlocking relationship, except to the extent they both deal with fees. But you're right, 1.5.1 brings with it its own set of unique issues that will certainly generate a lot of discussion.
Greg, I wonder if 1.5.1, the speaker signed tonight, might also speak to 5.4, because I know there is overlapping discussion when you talk about that rule, people misunderstanding that referral fees are different from ownership interests and fee sharing in general.
I agree. And I don't think 1.5 is really shouldn't take up too much time.
Right.
1.5.1 and 5.4 will, and I think Randy is right. There's more of a clear relationship in terms of the policy issues between those two rules, 1.5.1 and 5.4.
I don't mind doing 1.5, but I mean, in all honesty, the 1.5.1 and 5.4 is a tough, I just still can't wrap my whole head around the whole referral portion of it to be able to really, truly do a good job selling it. I mean, I understand it and everything, but I would struggle, I think, with that one in all honesty.
I could take them on. The only challenge I have is because I'm not engaged in the traditional practice of law for the past 23 years, but so I lack that practical understanding of how this works in real life now. But I'm happy to take those on because at least I'm a lawyer and I used to practice. So happy to take that on with some assistance.
So what I can do is I think it might be helpful with each of these rules that are set for individual votes is why don't I take on the job of explaining the rule and why it's written the way it is and what policy decisions are embedded within the language that the working group should consider, and then turn it over to whoever's the lead for that particular rule to explain the why, why you decided that this was the best option in terms of the policy decision that you made as a subcommittee.
And I'll also, so that makes a lot of sense. I'll also suggest that for these 2 rules in particular, and that's 1.5.1, the referral fees, and 5.4, it might make sense because we all do agree, but maybe for different reasons, that we all speak to why we are jointly proposing. Because again, I think we might be in the minority ultimately on both these rules, but I think we have reasons that we might all, it might make sense for us all to take a couple minutes to explain that.
I'm great with that. I think that makes sense, Amos.
Okay, so
Okay, so in terms of, I guess when we're assigning a lead, that would just be the first person to talk after I introduce the rule. So
I can be on 1.5.1 and 5.4. I could be the quote unquote lead.
Okay. So that will leave for you, Kim, 1.5, which is just the fees, and don't charge an unconscionable fee, and some other aspects, including the contingency fee cap, and then the advertising and solicitation of clients rule.
Okay.
Okay. All right. I think we have what we need to start preparing something to get out, unless I'm missing anything. Anything else?
What is the lead on the rest of the individual votes? Did you talk about that? I missed it.
Say it one more time.
The lead on the rest of individual votes?
I think that's it. There's only 9 now.
Right.
Each of you got 3.
Okay,
times.
so I missed what Kim got. So Kim got 1.5.
And 7.2 and 7.3.
Got it. Okay.
Can I ask?
What's,
Oh, go ahead. No, go ahead, Andrew.
just for my notes, what's Fariba's third rule? I have her with 151 and 54.
Oh, all right. You're right. 5. You get
Are there-
5.3.1 unless you would like to
Okay. Got it.
swap that with.
No,
Because
that's
you're the one that wonders why it shouldn't be in the group vote. So
I know. It should be in the group vote. Yeah, I
maybe
should get
Kim could
that.
take that one because she does not agree with that, and you could take 1.5 as well. Does that make sense?
What did you just say?
You could take 1.5, and Kim, you could instead take 5.3 in addition to 7.2 and 7.3.
Okay.
Okay.
All right, that works for me.
Okay.
Can I ask Greg about the group vote and
Yes.
if how you envision that working?
Well, I think one of the if we release the recommended revisions along with this table and an explanation of how we're going to approach it, and give everyone an opportunity to review the rules and propose if they wish to take anything out of the group vote category and have an individual discussion and vote on a rule, we'll allow them to do that. But once we get into the meeting, I anticipate having some introductory comments that reiterates once again, our general approach has been, and one I think that the court would support it to the extent this program would be approved by the legislature and the court, that the lawyer rules provide a base level of ethical standards that we will engraft and adopt vis-a-vis the paraprofessional, and that pretty much most of the rules that are in the group vote category simply have conforming changes to adopt those standards. There will probably be a few things I want to highlight where they're not the same, and I think we pointed out a couple. So I will just make a list of those things. And then I think leave it to one of you. I don't know, how are we going to do this? Are the subcommittee members going to move each of these rules themselves, or does a member of the full working group need to do that?
So the way it's worked so far is a group member can make the motion. I think that totally makes sense. I don't want to overthink this chart, but I find it very helpful. So let me suggest this. Maybe we can number the group votes so that we can reference them. And if it's by rule, obviously we could do it that way, or if we're going to combine them more, that's fine too. And then on the chart where it says group vote, we could actually say the number of it or whatever reference. So we know which rules are going together.
Oh, so you're still envisioning that we would break up the group vote further?
So you want one group vote for all the group?
I think that's what was being suggested by Kim.
Well,
that everything's in a group vote.
Here's my concern about that is that I just don't know if the work group members will read everything ahead of time. And I just, I think that it would be probably helpful to group them in a certain way. And then each of us maybe just present them really quickly. And then, ask if anyone wants to move any of those off the consent calendar and then call for a vote. Would that make the meeting longer?
Well, it's certainly going to make the meeting longer if people are not prepared to vote. So I think there's a limited amount that we can do to make sure people are actually doing the work ahead of time. I would hate to think that there are full working group members who have not looked at these rules at all prior to the meeting and are attempting to do that on the fly, because it's just really going to be very difficult for them to, as long as they want to make sure they understand the rule completely, it's going to be very hard for them to to vote on those things, no matter what we say in the meeting.
And no matter how they're packaged, like if it's one PDF or multiple, it's not going to change whether or not people read it. I personally think we should consolidate them, but Fariba, that doesn't preclude the kind of overview that you're talking about.
So right, I think that works for me too. Again, I originally was thinking split it up in some way, but I agree for efficiency and the way we're going, combining them. I do think that means Greg, you or one of us or somebody else here on the call probably does need to do high level, where the big policy decisions were. I think, it's one thing again to say same or not the same as the attorney rule, but I think there's also policy decisions that were discussed and were policy decisions made. I think it might help to have some sort of high level overview of that at the beginning too for the group vote. And what I'll suggest on this, again, this index, maybe for each of ones that we're covering, the individual votes, maybe we should propose what goes in that middle column. Some sort of description that I can just do for my couple, but maybe it makes sense, Kim, for you to do yours and Fariba for you to do yours. And again, we can edit them, but I think that space is going to be a very useful space to give some high level explanation.
Is that something that you guys think you can do by tomorrow? Because I would love to get this posted.
Oh my
When
God.
we post the agenda, again, like our best, our hope that working group members actually read this is, dependent on us giving them enough time to do it. And so that's what I would ask.
So can I ask mechanically what we're allowed to do and share? Because I think it requires maybe us to exchange drafts and edit them. And I'm happy, Fariba, if you want me to take a first draft of your two most controversial ones, I'm happy to draft something up. But I think we'd all need to look at it. So I can put a draft together today, I think.
Brady, I think that's fine, right? Because the working group's not voting on the summary that's written in that column.
Right.
Yeah.
Beckley Keene isn't about vote. It's about any communications within this group's subject matter. And now that we have 3 people.
But we've been
This is
exchanging
Beckley.
drafts of reports and editing them, or we're allowed to do that, right? Isn't this similar?
No, you're not supposed to.
Well, not exchange. They're not exchange. You're not exchanging them amongst yourselves. You're
Right.
sending them to staff. Right.
That's right.
Yeah, you're sending
Yeah.
them to staff. Yeah.
So,
Yeah.
but maybe we can do the same thing here. So I'm happy, maybe we assign out who's doing which rules, and I'm happy to get that out quickly. I agree it's important to get this out to the public as soon as possible.
Yeah, and really, I think the purpose of that middle column is just to make sure people are noticing that
Exactly.
something's different, and then go to the rule text, and we should encourage them to do this. That is only to trigger them that they should look more closely at that particular rule and see how it's written. So I don't know, we don't need to be 100% thorough. We just really want to make sure that we're highlighting that there's, these 3 issues with this rule that I want to make sure that you're drawing your attention to.
Okay, so I will do that for 1.4.2, 1.4.3. Fariba, I'll take a first crack if you want me to at 1.5.1. I'll also do 1.5.2 and 5.4. And I'll send that, Leah, to you.
Okay.
And Leah, when you say tomorrow, you mean tomorrow by 5?
Yeah.
Okay.
Yeah.
Because I'm not, yeah.
The magic hour. Yeah.
Okay.
End of the day.
I'll try to do
All
my drafts.
right.
And
And
staff will be working past 5 to get it out.
And then I'll do 5.3.1 and 7.2 and 7.3, right?
I thought you had,
Those are your 3, 5.3.1, 7.2, and 7.3, yeah.
who got 1.5? Amos?
Reba did,
Oh, okay.
but Amos has graciously offered.
Okay, I'll do that one as well. Yeah, I'll do a
Oh,
first
great.
draft of that.
Hopefully it won't take you too long, I'm hoping.
Yeah, no, I'll do that this afternoon.
Those are his favorites.
And we're just kind of putting the policy decision in there too, right, Amos? That's your thought, not just okay, I got it.
But very briefly, but that is my thought is just quickly, there was a policy decision here to, a new requirement, whatever.
Did we finalize what we're gonna do with the group vote? Are we gonna present them as a block?
Yes, we're
Where
gonna
did we end up on that?
do it as a block, but with your suggestion of an intro that outlines whatever kind of policy issues you all want to lift up. And I think we don't need to do that by tomorrow at 5 o'clock. We can work on the way we've been doing it, perhaps with the PowerPoints. You all identify rules that you want to specifically highlight within the group vote. And then one of you would sort of introduce the group vote and go over those issues.
Yeah,
Yeah,
because I think we
that'll
can
work.
definitely divide these into some that are the different, I mean, the first thing that caught my eyes are those that are not the same. And I think Amos has read that there's some policy decisions there or reasons. And then some we're just harmonizing with the limitations that are on paraprofessionals licenses, but not on attorney licenses. So I think we can group them like that. But
Just in
present them
terms
as
of
a whole,
discussion.
but the discussion piece, the presentation piece could be.
Yeah, I think you can imagine that there'll probably be a PowerPoint slide that just lists all the rules that really are essentially the same, except we've replaced the word lawyer with paraprofessional.
Exactly.
Right.
And then there'll be maybe 1 or 2 slides that highlights these are the rules that are in the group vote, but they're not the same, and these are the reasons why they're not the same. For instance, with 1.1, the competency rule, we've eliminated the exception to providing competent legal services that lawyers enjoy if they're providing advice or assistance in the case of an emergency.
Mhm.
So paraprofessionals do not have that safe harbor. They need to, if they're going to provide legal advice in that type of situation, it needs to be competent.
I think the other good news
Move on from there, because it's not, I don't think, we'll just move on from there, because that's not going to be controversial, I don't think. There may be some discussion like, I don't understand that, and we'll have to go back and forth until everyone has a mutual understanding of what we're talking about, and then move on to the next issue.
And I think the other good news is we actually spent a good deal of time at the last full working group meeting going through some of the policy decisions and some of the controversial decisions. So even on the controversial ones, it might be a little bit of a light touch. We might, explain why we think what we do, but we're not going to convince. I think there'll be some close votes on some of them, and that's fine.
Right.
I think my biggest concern is there's going to be quite a few of these just based on the last meeting and some of the votes on the items that we did take, that there's somebody that may want to vote no on a lot of these. And so then you're going to have to pull them individual, which is going to somewhat be I guess I could just vote no on the whole group.
I think the tricky thing will be if somebody wants to pull them all into individual votes, which would be a mess. I think it's fine if somebody wants to vote no in a vote, that's fine. But hopefully they're not going to ask us to do individual votes on every rule. That would be too much.
Yeah, that would be
For
difficult.
sure.
So I hate to say it, I dare to say it, but are we done with the rules of paraprofessional conduct for now? Because if so, we can move over to Brady, who still has some outstanding issues for you to consider, and then maybe use a few minutes to talk about the remaining work of this subcommittee, because there's still a lot of things for you all to get through. So
I'll just say for that chart, I might move my ETA to early in the morning, if that's okay, because I might go through some of the other rules.
Leah, there's one thing I don't think has been discussed yet, but was mentioned at previous meetings, which is the possibility of having alternative drafts of the most controversial items. And I don't know if the preparation should include actual, wordsmithing of a absolutely no fee sharing standard or an absolute no shared ownership standard.
I think for those two rules, it does make sense to have alternates for 1.5.1 and for 5.4.
And I think Steve Fleshman actually offers some alternative language. So he may end up offering it again at the meeting, but.
And I think Amos, you offered some last time, right?
So, right, I think we have, again, even for the alternative, we have some decisions to make of what the alternative, because I think there's more than one possible alternative. So my suggestion is that we do what Randy is suggesting, actually have for those, at least those two rules, an alternative. And again, there might be some wordsmithing at the meeting, but I really think, we want to set those up as we have a choice. Allow referral fees subject to what we're, the protections we're suggesting, or don't allow them. And if somebody wants to come up with a third alternative, that's fine too, but we're really choosing. And same thing with the ownership. Allow ownership with a minimum, minority interest, or don't allow it. And so I do think for those two rules, we should have the alternative.
The great thing is you're going to move it, right? Because you're the presenter, you're going to move it so you can get your vote done first. No,
Nope, Fariba.
Fariba, that's right. We're counting on you, Fariba.
Okay. I'm gonna apologize because I have to take care of something personal. My apologies. So don't assign me any more tasks.
All right. So we're going to have two alternate recommendations drafted for one for 1.5.1, one for 5.4. And other than that, we're good. Okay.
Yes.
Thanks, everyone.
Thanks,
Bye-bye.
Fariba. So Brady, what do you want to do?
I don't think we've got two off the list. I've got three that I still need to do a little bit more research, and I reached out to Araya. So given that we've lost Fariba, I don't know if it makes sense to go ahead or just try and cover this all next week.
I don't have a preference. I mean, I think you should put them up. Let's just give Kim and Amos a flavor.
Sure.
Because they're pretty
Yeah, let me share. Okay, so these are on attachment A of the, let me see if I can make this bigger. Okay. So beginning, this is attachment A to the memo, the OGC memo that went out for the June 18th meeting, June 25th, whenever our big meeting was, and we previewed these issues. We went through all of them there, and none of them seemed too controversial. So hopefully we can move them through, if not today, next week. But basically, the open issues that we've identified are in several areas: Code of Civil Procedure, Evidence Code, State Bar Act, and then we've got the separate provision on State Bar Act provisions regarding attorney duties, which we've already touched on today. There may be next week a few additional items from the Civil Code, but I don't anticipate much. Beginning with the State Bar Act provisions regarding attorney duties, the first three are from 6068I, which is the duty to cooperate and participate in disciplinary proceedings. 2 is 6068J, which is complying with the requirement to keep your licensing records up to date. And the third is subdivision O of 6068, which requires all attorneys to self-report basically a wide variety of things, but the filing of 3 or more lawsuits against them in a 12-month period, felony charges, disciplinary findings in other jurisdictions, judicial sanctions. And our recommendation on all of those 3 was that the legislature, that we make a recommendation to the legislature that in their enacting legislation, they impose these same duties on paraprofessionals because they're really essential to the functioning of the discipline system, and in the case of the records, the administration of the entire program. If for some reason the legislature didn't, we would take that recommendation that these need to be done and put them into a state bar rule to ensure that attorneys are subject to this requirement. The last two we just took care of, which are 6103.7, the report of suspected immigration status cause for discipline. That's now been included in our proposed rules of conduct, which was our staff recommendation, as well as the advocacy of overthrow of government provision. And then finally on the table was 6106.9, sexual relations between attorney and client, and all of that was already included in the draft paraprofessional rules. So I had prepared resolutions for those first three, but talking to Leah, that might not be necessary. It seems like maybe if these are, you know, I'll leave it to you guys on how to proceed, but it might be just that, you know, we report that we agree 60, 68, I, J, and O should be covered by legislation, and we can move that forward to the working group.
I'm
I would agree.
comfortable with that. That makes a lot of sense to me.
Okay.
And can I ask a question, Brady? So besides these in 6068, there were some others, and I'm sorry I don't have them in front of me because I think they were detailed in your memo, but it included things like statute of limitations on claims and some other provisions, and I'm not sure where we stand on that. I'm not sure that came before our committee. I don't know if that, or if it needs to, but are those other statutes where we might be recommending something on?
Yes, I wasn't done, so I'm just going through these
sorry.
sections.
Okay, sorry about that.
The next section, and this is really based on how we assigned the work, is State Bar Act provisions as well as State Bar rules that sort of are applicable to your work outside of the rules of conduct. So the first of those was the IOLTA statute, which is Business Professions Code 6210 to 6228. I think you're all familiar with it. Our staff recommendation was to recommend that the statute be amended to require paraprofessionals who hold client funds to open and maintain and place funds in IOLTA accounts under the same circumstances and to the same extent that attorneys are required to do so. The reasons for doing that are that basically treat attorneys and paraprofessionals who are holding client funds the same, and would serve the IOLTA program's goals of providing free civil legal services to the indigent. And we couldn't think of any reasons why not to do this.
Is there a minimum amount for attorneys? In other words, if a paraprofessional has smaller fees and smaller amounts, or doesn't have as much, I don't know what a burden it is to do this. So,
well, so
there needs to be a sort of a minimum amount or maximum amount.
That would actually, I think, actually tends to counsel in favor of putting those funds in, because the test for attorneys is, and I'm not going to quote this exactly, but that attorneys who hold client funds need to open an IOLTA account, and then they need to place in those accounts client funds that are of such a small value or are being kept for a limited amount of time, such that calculating and distributing the interest to individual clients would be, administratively, would not make sense administratively. The costs of doing so are going to be greater. And so I think that more funds held by paraprofessionals would actually fall into that definition than funds held by attorneys.
So I think that makes sense, although I think the reason the current language has more to do with larger amounts. So if a client is putting in, $3 million, probably that needs to be separated and the interest needs to be credited to the client.
Correct.
as opposed to smaller amounts, right? So I think on the larger side, that makes sense. The question is, if there are smaller amounts, if a paraprofessional is just going to have $100 or $300, do they need to go through all these procedures for that kind of thing? So at least maybe we should consider. If
That's
there
a-
should be sort of
That's a good question. And I actually don't know if there's a lower limit. Like, I don't know if there's a, I mean, if you're going to be putting them into a bank account, you might as well put them into an IELTS account, right? But is there any affirmative requirement to put funds into a bank account in the first instance? Although I'm trying to actually imagine this, because if you get a check made out to the paraprofessional for the client, he's going to need to cash that somewhere.
And hold it in trust, right? That is
Right.
that you are holding somebody else's money in that situation. So I'm fine with this. Sorry for the digression.
Yeah, we worked through it together. Okay, so I'll sort of treat that the same, Leah, as we discussed this and agree that this is one that can go forward to the committee.
Okay.
The next one was State Bar Rule 2.81. And this, I should actually get you the whole. Here's the entire language of the rule for attorneys. And that's that licensees, attorneys can claim participatory MCLE credit for speaking at approved MCLE activities. If they're a principal speaker, they get credit for 4 times their actual speaking time for the first presentation. And then if they do it more than that, they get the actual speaking time only. And that's for a principal speaker. There's for a panelist, for the first panelist presentation, they can get either their individual speaking time multiplied by 4 plus the actual time spent in attendance the remainder of the presentation, or an equal share of the total time for all speakers multiplied by 4. So basically, it's the time you speak times 4 for the first time you give a speech, and then actual speaking time only for subsequent presentations. There's no upper limit on this, and that's basically the rule for attorneys. When we discuss this, and so this is separate from teaching in a law school, which I don't think we're going to recommend providing paraprofessional CLE credit for. But the question is whether we want to give this same sort of credit to paraprofessionals for speaking at paraprofessional CLE events that attorneys have. The reasons for doing so would be we want to encourage them, to participate in the profession and educate others. There is definitely, you certainly learn something a lot better when you teach it than just sitting passively at a CLE course. And the question would be whether we'd want to go ahead with this same formula, whether we maybe don't give 4 times credit. It's open for discussion.
And the licensing committee actually has already recommended this, right? Didn't they? Was it the licensing committee, one of the committees?
No,
I think the CLE came through our committee.
Oh, did it? Okay, so maybe that's what I'm thinking.
And I would love to hear Fariba's view on this, but I am totally in favor of including this for the same policy reasons it's included for attorneys.
Me
And
too.
you learn a lot more when you teach.
Yeah. Maybe we'll just flag it just to mention next week when Fariba's here that we discuss this. We also want her thoughts, but our initial thought or to recommend a parallel.
And along with this, I do think it might make sense for you to be clear that you're not recommending for the teaching, just because I think that was a hot issue at the last.
Yeah, Julia brought it up, and I hadn't really thought as deeply about it. And once she made those points that these are all going to be newly licensed people, we don't even know that any of the once paraprofessional courses are established, that they would even want practicing paraprofessionals, non-attorneys to be teaching. So it just seems like this rule is too much too soon. And once Julia spoke on that, I think I agree at least. And then rule point 286, I'll report back next week. I'm going to speak with Araya about this. This is about that generally the way things work is a MCLE provider gets, applies for approval, gets approval, and then they can, give their course and licensees can get credit. This rule allows for a licensee to go to, some sort of professional event that's not pre-approved and then, submit the syllabus or outline or whatever and try to get that approved for MCLE credit. I'm not even sure how often this happens, so I'll find that out. But the reason maybe for not doing this is the administrative headache, and that this is a new program. Why not just have tighter control and limit the CLA to pre-approved events? So I'll get some more information about how that works in practice for attorneys, so we can make an educated call there. The next section was Code of Civil Procedure. First, you mentioned this, Amos, 340.6. That establishes 1 year statute of limitations for claims against an attorney for wrongful acts or omissions. This is sort of an open question. Our initial recommendation to staff was to apply this on our default reasoning that paraprofessionals practicing law should be treated as attorneys practicing law. Steve Fleischman raised that there may be concerns or opposition to this because this is seen as a very pro-lawyer provision rather than the longer statute of limitations that would apply to a general negligence malpractice case. And that it's more protective of attorneys than of the public.
So this is one I don't know that we should just push along rubber stamp. I think we should consider this. I don't know if now is the time that we should wait for FREBA, but it's a tricky one. Yeah. And again, I think might get a split vote if it were the full working group.
I'll come back. I think it's a I think the alternative is a 2-year statute, but I think the default, if we didn't create a special statute, would be 2 years, but I will confirm that, confirm what the alternative is if we don't act.
And I'm just wondering what the reason would be to do different from what the attorneys have.
To protect the public more.
Okay.
I don't know the history on this, but I would imagine that lawyers lobbied for this. And they're while on the one hand, we've tried to treat them the same in a lot of ways. I think that I've heard, at least in some discussions, concern about providing greater protections to the public, given that we're creating this new licensing category, and there might be perceived greater risks.
You know what the statute of limitations is for fee disputes, if there is one? Because this, I think, just applies to malpractice actions, but for fee disputes, that might be different.
It's complicated. Depends if it depends a written or an oral agreement. And then the Supreme Court in 2015 issued a case, Lee versus Hanley. And if there's a sense of if part of the fee dispute is associated with a malpractice claim, then the 1 year statute that applies to malpractice claim is also tied in to the fee dispute. So it's complicated.
Yeah, so and some lawyers have the practice of putting in their written agreements, you have 60 days to dispute, otherwise this is final or something like that. I don't know if it has any effect, but I've seen that. But I'm just wondering because fee disputes might be, a bigger concern as well.
And to your point, Brady, just something else to think about too is these individuals could actually be working with this client. They could transfer over, have to, because of what they're doing, transfer over to an attorney, and it might not be until a little bit longer working with that attorney that it actually comes up that there was something done wrong, and then they could let them know, like, hey, this was done wrong, to go back. So it might be a reason for making it longer than that 1 year. That's just kind of a thought. I mean, it is definitely a consumer protection issue, but that maybe is a reason to explain why if we did extend it longer.
Yeah, and I mean, I think that in that situation, you'd probably be able to argue some sort of delayed discovery, but
Okay.
but it would certainly be easier if you had a wider window and didn't have to get to what did you know and when did you know it. So I think that's a very good point.
And I think I'd like to, I haven't made up my mind on this. I think I want to look into it a little bit more. So I think this goes on the, let's discuss further.
Okay. The next was a provision about personal sureties on bonds. And there's a provision that the surety it must be a person other than the principal, and no officer of the court or member of the state bar shall act as surety. In my initial research, I haven't been able to find out how this is actually applied in practice, how often this comes up. Randy, have you guys had any experience with this provision, 995.510?
I don't think so.
So I'll keep digging and see if I can find out how more, if anything, about how this works in the lawyer world. It doesn't seem to be a very well-known code of civil procedure, and report back.
Andrew, has it come up at any COPRAC discussions or hotline inquiry?
Sorry, can you say the issue one more time?
This Code of Civil Procedure 995.510 A provides that a personal surety on a bond is sufficient if all of the following conditions are satisfied. One of them is that surety is not an officer of the court or member of the state bar.
No,
And
I've never
come across that.
haven't tangled with this one.
And it's sort of strange because I think that it's referring to, when litigation's going on, when you need to basically stand up and guarantee that somebody's going to appear somewhere or do something, that you can't. It would make sense if you can't be their attorney, but this seems like a ban on any member of the state bar ever acting as a surety. We'll try to find out some more. And then the last one, the big one on Code of Civil Procedure was the attorney work product provisions codified at 2018.010 through 2018.080. They codify the absolute and qualified work product doctrine for attorneys. The statutory purpose is preserving the rights of attorneys to prepare cases for trial with the degree of privacy necessary to encourage them to prepare their cases thoroughly and to investigate not only the favorable but unfavorable aspects of those cases, and preventing attorneys from taking undue advantage of their adversaries' industry and efforts. Those rationales would apply equally to paraprofessionals practicing law. And here I think there's an added rationale for treating paraprofessionals and attorneys the same, in that if you have two parties and one's represented by a paraprofessional and one's represented by an attorney, if you don't apply the attorney work product doctrine to the paraprofessional, a lot more of their work and strategy subject to discovery by the other side, then they would have a window into what their opponents are doing. So it would create a big disadvantage for potentially for those represented by paraprofessionals.
Yeah, this is a critical one for sure.
And I would agree, they should be the same.
Should we mention this to Fariba next week that before moving forward?
Yeah.
Nobody seems to have any objections to it, but.
Well, I was going to suggest, Brady, for these, that the ones that you've gone through that where both Kim and Amos feel like, yes, let's go for it. I think you should, if you can, schedule a separate call with Fariba So we
Okay.
don't have to take up meeting time to like re-go over them. And maybe just dig in at the next meeting to the ones that kind of need more discussion or research.
That's a great idea. I will do that.
Okay.
Similarly, on the evidence code, we've got evidence code 912C, 917, and 950 through 962, which establish or reference the lawyer-client privilege. Let me find that alarm going off just for 1 second. All right. So basically, for the same rationale that we would want to apply the work product doctrine to attorneys, to paraprofessionals, we would want to apply the lawyer-client privilege. I would note that, I don't think this is my notes here. Let me find 950. The way the privilege is currently defined is arguably would already include paraprofessionals, because evidence code section 950, as used in this article, lawyer means a person authorized or reasonably believed by the client to be authorized to practice law in any state or nation. You know, I think the best reading of that is that it would include somebody going to a paraprofessional to do practice of law activities. But I think I would recommend that be clarified to include including licensed paraprofessionals.
I agree. There shouldn't be any doubt that the privilege applies.
Yeah.
Agree as well.
Okay. And that is it. Great. So I've got homework on a few of those to get some more information, and I will speak with Reba on those where we're in agreement.
And what I was also listening for were other things that we might want to add to the rules of professional conduct, but I didn't see any. So is it right, Brady, that it's your recommendation that none of those additional things that we just went over, at least at this time, need to be added to the rules of professional conduct?
Correct.
Great.
Right, great. So in addition to kind of working through all of the outstanding policy questions with Brady, we then need to turn back to proactive regulation, because we've got to bring forward a recommendation in August. I also think, per your email exchange with Justice Patru Amos, this group is going to take up some further refinement of the, I forgot what we're calling it, not a board, the oversight committee, the paraprofessional oversight committee, the governance model. So those are the two kind of outstanding topics. Linda, if she's still here, am I missing anything for this subcommittee?
I need to take a look.
Okay.
So last time I had a short list of additional things I can just mention to see.
Okay. Yeah. Sorry.
And I don't have that in front of me either, but I just made some quick notes. So I agree. The structure of the oversight committee, I don't know how much time we need to devote to that, because I think my comments I made mostly at the full working group meeting, but I think it is worth some time. And I don't know, Lee, if you have a suggestion of what the steps forward should be on that, but I do think we want to work on that. The fraud by non-licensees, and thank you, Leah, for sending something around on that. But I do think either this committee or maybe that will be a joint meeting with the discipline subcommittee to try to move that forward. I think I had on my notes that we need to do something on evaluation. My recommendation was that be a new subcommittee that is formed to talk about evaluation, but it might overlap a bit with the proactive regulation.
Yeah, we do have evaluation on the agenda for the 26th. And I invited these folks. So the National Center for State Courts, this is going to get posted when we post the agenda, this being a document I have in my hand. The National Center for State Courts has recently promulgated a recommended kind of evaluation framework for what they're calling access to justice programs. So basically, in recognition of the fact that these are popping up kind of all over the country. And they're going to come to our meeting to talk about this framework. And I've also got the folks from the University of Utah who are doing the evaluation of the Utah LLP program to come and talk to us about that evaluation framework, the whole working group. So I think, Amos, like based on how the discussion goes, we'll see if it makes sense to, you know, establish a new subcommittee to really flesh out specifics. I'm kind of thinking at this point, it's going to be outcome and process measures that the working group feels are critical to collect rather than a fully articulated like evaluation framework, but we can see how the discussion goes.
I won't necessarily volunteer to be part of an evaluation subcommittee, but I will tell you that I did participate in some of that discussions for Shriver, in the Shriver evaluation, and outcome collection is very tricky, like for eviction defense of what the outcome is a favorable outcome, because there's just a lot of, it's not just a checkbox. I think it can get very complicated by practice area of what's collected. So I just think probably there needs to be a deeper dive on that for evaluation to be useful. But that's all I'll say, because I'm happy if it's not on our.
Yeah. And they're actually, I mean, I think both presenters are going to talk about that, particularly the Utah folks, because they started with like this really grandiose set of measures, and then just the actual ability to like feasibility and also cost, you know, are huge considerations. So we're going to hear about that.
And burden, right, on the paraprofessionals for it's a big issue.
Yeah.
The last thing I'll say is on the naming, and Leah, this really is a question for you. The name of the program came up several times in our subcommittee. We were talking about advertising and our concerns about that. Some of that was articulated, I think, during the full working group, but really it looked like it might go in a totally different direction, which is just, you know, picking 3 names or letting the board decide. I think our subcommittee should be weighing in on that, or at least with our recommendations or concerns. So I just don't know where that stands right now.
Yeah, I think there's nothing to prevent you all from coming up with a recommendation. I think Justice Petrie's idea is we would submit 3 names to the board, but I don't think there's any reason you can't come up with a recommendation.
Well, do we get to know the 3 names? Because we might have concerns.
Yeah, I feel like they're, oh, well, that's a great question. I don't know. I was gonna say what I thought it was, but I don't know. So I will, that'll be my homework between now and next week.
That's great, because I do think before it's submitted, it would be great if we could potentially comment on sort of the regulation subcommittee's view of concerns about, you know, 1 or more of those choices, or come up with a 3rd. But if there's already a list, that would be great.
Okay.
And in terms of what gets submitted to the board, the full working group is gonna have the opportunity to review the report, which will include those recommendations before it's submitted.
But not necessarily the concerns that we as a subcommittee have identified for, you know, fraud and misuse and misunderstanding related to advertising, including the name of the program.
Okay. All right. So we've got proactive regulation. We've got the governance structure. On UPL, then it sounds, Amos, like you are going to want to see another meeting called, because we'll work to get that scheduled. To finalize, that was one of my questions in the email.
Yeah, so we talked about that last time, and I think what we were going to try to do is jump on one of the existing meetings and add that to the agenda. I don't know if we need a full meeting, but I don't know if we have something scheduled that's coming up.
And we were saying bring them to this, bring discipline to this committee, Leah, because discipline doesn't meet again until August 20th. So if we wanted to do it before then, we were thinking of coming to one of the regulation subcommittee meetings.
Okay, inviting members of discipline, which is you already, Kim. So,
Yeah.
okay, that's a great idea.
But we can find out, because we have these meetings scheduled every week, and as long as it's in advance of when the agenda is posted, we can have it be a joint meeting.
Yeah, okay. We'll poll the other discipline committee members and see which Thursday works for them.
And hopefully we don't, I don't know, Kim, if you have a thought about how much time. I haven't looked closely at what Leah sent around, but I think, you know, a half hour or 45 minutes, you know, is probably going to be good.
And you want to do it before this isn't going to go until the August meeting, right? And so it needs to happen, you're saying, so but well in advance of that meeting too. Well, but
So I think our
on
recommendation.
the August 20th will work.
I'm sorry?
I'm just wondering, the discipline committee meeting on August 20th, that doesn't work to combine.
We were just thinking of doing it earlier. That was the only thing, Linda.
Okay.
I'm okay with whenever. I don't have a strong preference.
Okay.
So my last thing is, it sounds like we will get through the Brady items by next week. Do we have one of these calls next week, even though we have the board meeting? We must. It's just I won't be able to be on it. Okay. So I think we'll be able to move forward to some of these other topics. So maybe I will have the 3 names. We'll follow up on Brady's work. We'll have the 3 names. I think, Linda, you can review the email string on governance, which I think I sent you, to make an amended sort of proposal for this subcommittee to review based on that Amos's feedback. So maybe you guys can tackle those things next week, and I guess like finalize the presentation. Does that sound good?
When were you planning on doing proactive?
After that, because proactive is not going to go till August. So I think after next week, our remaining meetings we can spend on proactive regulation.
Sounds great.
Okay, perfect.
Right.
We're ending early. Thanks.
But the work's not done, I feel like.
Thank you so much, Andrew and Greg, Randy, but
Yes.
thanks for putting it together.
Can I just ask one quick thing? Could someone send me just the most recent version that we have? I probably have it somewhere, but most recent version we have of all the rules of conduct that I can, professional conduct that I can look at to put the middle box together.
It's included in the email I sent on Tuesday. It's one of those multiple.
Okay.
One of those multiple attachments has it's one of the documents has the entire set of rules clean, followed by the red line.
Okay.
And I think I have to create another, and I just sent an updated table during the meeting. I hope you received it. And I think, just want to confirm, I have to create one more document. I'm going to create one document that has a running list of the rules numerically that will require an individual vote. And I will create a single document that has the list of rules that we are designating for a group vote following today's discussion. And I'll send that to staff for posting. Is that correct? And the format was clean and redlined. Did people have problems? Not problems. Would they prefer a different orientation, or is clean followed by the red line okay with the 2 of you?
It's
fine with
fine. That's fine. As long as I can see all the final edits that were in there, I'm good with it. Looks good to me.
The only other thing is G and H. I'll add G and H back to 8.4. That won't be in the document you're looking at, Kim, but
Okay.
it's probably in one of the prior, the last meeting's rule that went around. If you could track that back down. I'm not sure. I got another meeting here in a few minutes. I'm not sure I can get it to you by the end of the
That's
day,
fine.
but
I could
I'll
send you
get those rules.
I think it has it in there.
Can I just ask, Andrew, I wasn't clear. So the documents you're putting together, that will be for circuit posting and for circulation, are you breaking the rules up into the group vote and the individual vote? Because I don't think that makes sense. I think it should be one document with all the rules. And then we're going to have individual resolutions on the individual
fine.
votes, right? Because
Okay,
I don't
easier
think
for
we
me.
should have, I don't think we should have a full list of the rules with the important ones or the controversial ones pulled out.
I agree. Yeah, that'll
Sounds
be
good.
easier too.
I apologize. Yep, I'll just do one group, one document that has all the rules, and you'll present them differently. And then there'll be the table with your, you, Kim, and Freeba's additional edits to the middle column.
Right, but we might want to put together, proposed resolutions that break it up for individual votes separately, right? That we can, put on the screen or something.
Sure.
Great.
Okay,
Okay,
thanks
thanks.
everyone.
Thank
Thank
you.
you.
Bye.
Bye.